Hi, I'm muted. Well, I was, not anymore. Welcome, and I'm only 6 minutes late. That's not bad. I've been working on a video like all night. No, literally from like, I don't know, I want to say 7 from the time it happened until now. I was working on a counter to count how many times this soft sit objected. And every time I've exported it from the editor, something's going on with the sound. So I don't know what I'm going to do. But what I do have is some Judge Weaver that share, who's a favorite of mine. And I will just share it like so. And then I'm no longer big on the screen, ideally. Okay, perfect. And here we go. Let me know if you can hear it.
Oh, you are hot.
Yes, I was wearing one earlier, but I removed it when I knew we were on video.
You didn't want to disrobe. All right, we're YouTube Live. That's sad. Good afternoon, everybody. My name is Walt Weaver. I've been assigned to hear these cases today. I'm going to call you forward, and at that time, we'll do your trial.
He's probably one of the top
William Perry
5.
Walker Jr., would you please approach? Who's the attorney for Mr. Walker?
That's me.
Oh, Aaron?
Yes.
I missed. All right, Mr. Walker.
Yes, sir.
My name, did you hear me when I introduced myself earlier?
Hey, Hayden.
You said Weaver?
Yes.
How you doing?
I'm doing good, sir. How are you?
I'm blessed.
Good, good. Well, I've reviewed the plea papers in this matter. It looks to me like you're prepared to waive your constitutional rights in exchange for the plea bargain agreement. Nonetheless, you have the absolute right to appear in my open courtroom and face your accusers, or you could waive that right as well. Are you agreeing to appear by video today?
Yes, sir.
Thank you, sir. The court now calls for trial, cause number CCCR-23-384-1, the state of Texas versus Willie Perry Walker Jr. What says the state?
States are ready, Your Honor. You should also have another cause there for Mr. Walker.
Thank you. And then cause number 22-192-1 also being called. Is the state also ready?
Yes, Your Honor, that one's a motion to revoke, and we're ready on both cases.
Okay. What says defense counsel?
Defense is present and ready, Your Honor. We waive the reading of the information on the first case and the reading of the motion on the other case.
Thank you, Ms. Mullinax. Again, good afternoon, Mr. Walker.
Yes, sir.
Were you aware that today is your trial for both this original action and your motion to revoke? One being assault, domestic violence, a Class A misdemeanor, and the other a motion to revoke on your unlawful restraint, also a Class A misdemeanor?
Yes, sir.
Do you read, write, and speak the English language?
Yes, sir.
Have you in the past or presently being treated for any kind of psychiatric condition?
No, sir.
Are you a United States citizen?
Yes, I am.
To the stated accusation of assault, domestic violence, how do you plead, guilty or not guilty?
Guilty.
Thank you, Mr. Walker. Are you also Willie Perry Walker Jr. as well as Willie Perry Walker?
Yes.
Mr. Walker.
They just took the junior off one of them. That's all.
All right. That's like the government always taking stuff from you. Now, are you also the same Willie Perry Walker who pled guilty to the Class A misdemeanor offense of unlawful restraint?
Yes, sir, I am.
Did I already ask you if you pled guilty on the assault DV?
Yes.
All right, then. And to the stated accusations of probation violation, are those accusations true or not true?
True.
All right, then. I don't have the motion to revoke in front of me that I could find.
Your Honor, the sole allegation on the motion to revoke is the new charge that he just pled guilty to.
Thank you so much.
Sorry.
That's all right.
Okay.
Mr. Walker, before I accept your plea of guilty or plea of true, I do need to make an inquiry on the record as to your understanding of today's proceedings. Before me, I have the 2 negotiated plea bargain agreements that you're asking me to follow. Attached to it is something called a plea memoranda, and both reflecting your signature. Do you recall signing the plea memorandums with the assistance of your attorney prior to today's trial?
Yes, sir, I do.
Your signature tells me that you know you have constitutional rights and know how to use them, but today you don't want to in exchange for the agreement. For example, do you know what a jury trial is?
Yes, sir.
On the assault DV case, you have an absolute right to a jury trial. Would you like to have one?
No.
Right then. Mr. Walker, I feel like you understand the rights that you're waiving as evidence by your conversation with me, your answer, your signature in the plea memorandum, and most importantly, your attorney's signature. That tells me that you understand the rights that you're choosing not to use. So I don't feel a need to read all this to you, and I'm not going to, but I would like to talk to you under oath about a few things.
Yes, sir.
Mr. Walker, you have an absolute right to remain silent. You waived it by pleading guilty. You have an absolute right not to give evidence against yourself. You waived it by signing a judicial confession. No one can make you do any of those 2 things, Mr. Walker, but if I believe it and accept it, that is enough evidence today at your trial to support my finding of your guilt. You understand that?
Yes, sir.
My question is, will you waive your right to remain silent and let me put you under oath and let me ask you a few questions?
Yes.
Headphones are dead.
Raise your
This
right
is
hand.
Just a great start.
You swear or affirm to tell the truth?
Yes, sir.
All right, put your hand down. Willie Perry Walker Jr., did you
You guys
voluntarily
can still hear it,
sign?
right?
Did you voluntarily plead guilty and did you voluntarily sign the judicial confession only because you were guilty and for no other reason on the assault domestic violence?
Yes, sir.
Are you satisfied thus far with your attorney's representation of you?
Yes, I am.
Ms. Mullinex, do you feel comfortable expressing an opinion if you have one as to your client's competence to stand trial?
Yes, Your Honor, I believe my client to be competent.
Thank you, Ms. Mullinex. Mr. Davis, has the state complied with the Michael Morton Act in both these causes and that you made available to the defense the evidence in your possession?
Completely in both causes, Your Honor.
Because I can't.
Thank you, Ms. Davis.
So
Ms. Mullinex, in both
gonna
these
try to fix
causes,
that.
are you satisfied the state's complied with the Michael Morton Act?
Yes, Your Honor.
Did you discuss with your client the evidence in both of these causes?
Yes, Your
Thank you, Ms. Mullinex. Mr. Walker, today's your trial for both of these allegations. The state did an investigation. They felt confident they could prove your guilt beyond a reasonable doubt on the original offense and by a preponderance. Is that the burden of proof on a motion to revoke? Yeah, that's
Yes.
what I thought. In the motion to revoke, they turned over all the evidence that they secured to your defense counsel. Mr. Walker, did you have a conversation with Ms. Mullinex about the evidence that the state wants to use against you today?
Yes.
Today, you face up to 1 year in jail, up to a $4,000 fine, or some combination of fine and confinement. On the assault DV, you're saying, Judge, sentence me to 180 days in jail, no fine, give me court costs, give me 54 days jail credit. This is an attempt on your part to negotiate what is called a time served sentence as to confinement, fine, and court cost, leaving you with no obligation. This debt will be served. Did I announce your agreement properly?
Yes, sir.
While I'm not bound to follow this agreement, Mr. Walker, I will tell you if I choose not to, and I'll let you withdraw your plea of guilty. It couldn't be used against you. It's your future jury trial. But give you what you want today, and later you think it was a mistake. Someone made you do this against your will. You didn't understand me. Whatever your contemplated error is, unless you reduce it to writing today so I could try to fix it after reading it, your odds of winning that mistake later on an appeal or a writ are very, very difficult. You understand that?
Yes, sir.
Anything about this conversation make you change your mind about your decision to plead guilty to this accusation?
No, sir.
Willie Perry Walker Jr., I find your plea has been made knowingly, intentionally, voluntarily. Further, I find the evidence sufficient to support finding of guilt beyond a reasonable doubt. And I now do find you guilty of having committed the Class A misdemeanor offense of assault alleging domestic violence. Mr. Davis, anything in bar of sentence?
No, Your Honor.
Mullinex?
No, Your Honor.
With nothing in bar, having previously found you guilty, I sentence you to serve 180 days at the Potter County Detention Center. I will assess no fine, but I will assess court costs. I'll give you 54 days jail credit. This is the time served sentence.
It's
Proceeding on
Potter
to
County.
the,
I'm trying to
motion
fix
revoke
my
probation.
issues, and
You have a lot of the same
I'm
rights
working on
as
it.
you did on the original plea, except this is a trial just to the judge. You don't have a right to a jury. And all I got to do is find one probation violation. And if I find that, then we go on to punishment. Now, the little snafu on this is that any plea bargaining agreement you made on this is not binding on me if I find a allegation to be true. But here's my promise to you, Mr. Walker.
Yes, sir.
If I find a probation violation to be true and I want to revoke your probation, and if I don't like the sentence, I'll let you withdraw your plea of true and we can have a trial in person, and then you can bring in whatever witnesses you want if you felt any need to show why this original punishment is correct. Do you understand that?
Yes, sir.
So there's no risk today. Likewise, you have no duty to give evidence to get yourself in this trial as well. But I need to know a few things before I can go forward and revoke your probation. Do you understand that you don't have to testify?
Yes, sir.
Will you waive your right as well in this case and let me ask you a few questions?
Yes, sir.
I would remind you that you're still under oath, Mr. Walker. Are you the same Willie Perry Walker who on October 7th, 2022 pled guilty to this offense of unlawful restraint?
Yes, sir.
At that point in time, after being found guilty, were you then placed on straight probation? What was the original underlying sentence, Mr. Davis?
180 days, Your Honor.
All right. Were you then sentenced to 180 days that was probated for 2 years?
Yes, sir.
After that sentence, were the rules and conditions of probation explained to you?
Yes.
All right, then. After that, the state's alleging you violated probation, and they gave you notice of the alleged probation when they filed this motion to revoke probation. Were you served with a copy of this motion to revoke probation, or did you discuss the alleged violation with your attorney prior to today's trial?
Yes.
All right, then. It's been alleged that there's only one violation. You already pled guilty to it. But what I need to know from you is this alleged violation a violation of condition number 1 by committing the offense of assault causing bodily injury to a family member on or about November 13th, 2022 in Potter County, Texas, true or not true?
True.
Thank you. Mr. Walker, I find your original plea was made knowingly and intelligently and voluntarily. Further, I find the evidence sufficient to support that finding of guilt that has been previously made. I do find that there's been a violation of the terms and conditions of probation. As such, I'm going to revoke that probation. And it appears that the original sentence is being imposed. Is that correct, Mr. Davis?
Yes, Your Honor.
Mr. Molinax, is that your understanding?
Yes, Your Honor.
And Mr. Walker, is that your understanding?
Yes.
All right, then I'm going to impose the original sentence. I'm sentencing you to serve 180 days. I won't impose a fine. I will give court costs, give you 56 days jail credit. This also appears to be time served. Now, in both these matters, Mr. Walker, I did what you asked me to do. I imposed the plea bargains you requested. In either one of these cases, would you like to file a notice of appeal complaining of a mistake or an error?
No, no, sir.
Would you like a new trial?
No, sir.
Mr. Walker, what questions do you have for me?
I just want to say I appreciate you. I thank
All
you.
right, Mr. Walker, I hope I see you at Walmart somewhere and I'll say hello, okay?
Yes, sir. Well,
All
if
right,
I get out, man. Just come see me at Mars. I'm going back to work. Yes, sir. I
Mr.
appreciate it.
Davis, any other matter before the court?
No, Your Honor.
Ms. Mullinex?
No, Your Honor.
All right, then. Thank you guys for working it out. Good luck. Give a fingerprint to the deputy. Court is adjourned.
Thank you.
Have you excused, Your Honor?
You may be, Ms. Mullinex. Take care. Brianna Privet?
He's one of the most personable
Brianna
judges.
Privet, would you please approach?
I just want to like hang out with him at a dinner.
Who's Ms.
party.
Privet's attorney?
That's me, Your Honor. Tate.
All right,
Uh,
thanks, Tate.
There's only one time that I have seen this judge mad, and I am about to show you. Okay, new incognito window, drag the file, enter, okay. Now I present the new screen. Here we go. And this is from a couple of weeks ago, I think, before he got rid of the stash. And he he takes his judicial oath very seriously and sometimes even literally when he wants to. Here we go.
Are you Mr. Matthews?
Yes, sir.
I have your name as Nitraven Matthews, spelled Nytravin. Middle name Maute, last name Matthews. Is that all
Yes, sir.
correct?
Yes, sir.
You're charged with a Class B misdemeanor offense of criminal trespass. If the state can prove their case, maximum punishment is 180 days in jail, up to a $2,000 fine, or some combination of fine and confinement. Because you find yourself charged by the state of Texas, you're absolutely entitled to be represented by a lawyer. You can hire a lawyer, or you can have one court appointed. What would you like to do? Would you
Yes,
like
sir.
to,
I'm sorry, can I ask a question?
after I'm done,
Oh, okay, I'm sorry, go ahead.
what would you like to do? Are you going to hire a lawyer, or do you want one court appointed?
You know, I had a question. I was wondering, like, if you said, now, what was the charge again?
Class B misdemeanor criminal trespass.
Okay, if it was just trespassing, would I be able to get time served on that if I was saying, because I didn't mean to walk upon the grounds, but there was an accident?
If you said you didn't mean to walk upon the grounds, that means you are innocent.
I know that, but like,
Now-
but I
Now,
would
sir,
rather.
you cannot talk when I'm talking.
I'm sorry, sir.
If you say you did it on an accident, you are not guilty, and the prosecutor, who is the one who makes these offers, would relay an offer in exchange for your guilty plea. You just told me you're not guilty.
No,
There
I'm
we
sorry.
go.
I'm
Sir,
sorry.
you really cannot interrupt me. Ergo, she cannot make an offer to you.
No, I wasn't gonna say I'm not guilty. I was gonna say I'm guilty. That's what I was trying to say.
You said you walked up on accident. That's the mens rea, the
No.
middle element, which
I
means
wasn't-
that, sir, we're done. You're excused.
No, I'm not. I wasn't done talking. That's what I was saying.
You're done.
I was trying to tell you, I meant to have walked up on the property. I did walk up on the property. I was guilty, but you wouldn't let me say it. You were trying to say that, but you didn't let me say that yet.
It's not what you said. You said you walked up on accident. You're excused.
No, I wasn't done talking. I said my mom's went crazy, and I just walked up because I thought somebody called me over there. I wasn't ready to. I wasn't didn't say the whole sentence. I'm sorry.
Good. Are you done talking?
Yes, sir.
You're excused.
So I don't get a plea bargain or nothing.
Not
No.
today, not in front of this judge.
It did that on purpose.
I mean, you can't
I'm sorry.
do it.
I'm not gonna lose my law license on YouTube Live.
He said, when I just told him I wasn't guilty, I stopped. I explain him why. I thought the whole thing was, oh, my God. Well, no, I'm still being explained if I'm guilty or not guilty.
Would the next person please approach?
Because right now, I'm not going to explain. I walk on there, but I'm guilty. I walk on there, I'm guilty. I am guilty. I don't say that. Why do you say now?
Bring back what? I'm not gonna.
Why?
play again.
That makes no sense. You can't just do that. So can you tell me how long I'll be here now? Well, I'll start a problem with everybody, including you two. Right now. No, don't say what, no, that would be 5 months now while I talk to the judge. That right there was.
Oh, sorry. Yeah, that guy just definitely talked himself into jail.
Do you want us to call 911?
I'm glad you're here. That was for property, but he just did. He didn't even let me tell him if I was guilty or not guilty. No, I'm not. Well, he let me tell him I was guilty or not guilty. Now I have to, now I have to be here for 5 freaking months because he didn't freaking sit there and listen to me say I was guilty the whole story.
I mean,
No, but I'm saying watch, because then how you take your extra jail cell and say what's for the next rating, which is 5 months down from now, and he didn't even let me say if I was guilty or not guilty.
dude, that guy's still going.
No, and he didn't let me say so. No, I was explaining to him, I was done saying guilty or not guilty. That's what I was trying to say. He freaking cut me off and said that shit. So it's not pretty fair. So now, so like, what the fuck do you figure out this whole?
I don't know. I think contempt would be appropriate. I wouldn't want to follow that though.
Hi, good afternoon. My name is Walt Weaver. I'm the judge of Potter County Court of Law number 1. And as you may have learned, sometimes it's better just to listen. So,
Yes, sir. Yes, sir.
yeah, if you offer an explanation, we're at risk of losing our law licenses. And the individual before you gave a defense, which said he was innocent. So we're going to give him some time to think about it. Maybe he can come back tomorrow in front of a different judge. But this is an arraignment. All I'm going to do is check on the spelling of your name and the accuracy of this charge. And because you're charged by the state of Texas, you're absolutely entitled to have a lawyer help you. You can have one hired to represent you or have one court appointed if you ask. I have your name as Ernesto Luis Gonzalez. Is that correct?
Yes, sir.
All right. I have your name spelled E-R-N-E-S-T-O, Luis or Luis, L-U-I-S, Gonzalez, G-O-N-Z-A-L-E-Z. All correct?
Yes, sir.
All right. Mr. Gonzalez, what are you going to do about your legal representation? You have a hire a lawyer or do you want one court appointed?
Court appointed.
All right. That's a great choice. The deputy's going to give you a form. Fill it all out. Really, it's just checking on how much money you make, what your bills are. If you qualify, you will know today. And the attorneys are pretty good about getting out there immediately because I don't want you sitting there longer than possible. Do you have any questions?
Just how long I'm gonna be sitting in here? Because I have a CPS case that I'm dealing with at the point right now, and I'm
Do you
just,
have a bond?
Yes, I was actually I was filing for a bond reduction and whatever, and it's 10,000, but right now I don't have a job or anything. Well, it's 5, but it's two different charges.
Yeah. It says TD Hammonds is your lawyer on some felony.
Yeah. They said I have a. Go for it.
The bond on this is only 2,000, but if you can't make the bond on the felony, there's no reason to make a bond on this. So if I appoint TD to represent you on this, he can work on reducing all of the bonds.
The felony charge, I'm not sure which one that is. I think it's unlawful carrying a weapon and
Well, this,
or possession.
this to me is unlawfully carrying a weapon. It's Class A.
Yeah, they said that that I had the weapon with me when I had got pulled over.
Don't talk about the facts of your case because that's a prosecutor right here.
Okay.
And
Okay, yes, sir. Yes,
this
sir.
isn't about talking about the facts of the case. Even
Okay.
if I thought you were innocent, I
couldn't
couldn't
do
sign a dismissal. It's completely up to the prosecutor.
Okay,
So
okay. Sorry about that.
you have a lawyer. I can appoint TD Hammonds on this. If you'll fill out that form and just write at the bottom, was TD appointed on the felony?
Yes.
All right. So write that down. We'll get that done. And then you contact TD, call him and ask for a bond reduction. Okay?
Yes, sir.
What questions do you have?
Am I eligible for like a PR bond or anything like that?
Well, it wouldn't matter if you make bond on this, but you don't make bond on the felony. That means you're actually sitting in jail, not getting credit for this misdemeanor, even though you're in jail.
Yes, sir.
You need bond on both of them. That's why if you get TD Hammonds, you should talk to TD Hammonds.
Yes, sir.
Anything else?
No, sir.
All right, then. Thank you very much.
Thank you, thank you.
Deputy, sorry about all that.
Are we just gonna put him on the list for next week?
Yeah, or if he can talk to a judge tomorrow, I don't care. I mean, he just can't, he presented a defense of innocence.
Yes, sir. I've tried to explain that to him, but he wasn't wanting to listen to it, so.
He wouldn't let you finish your sentence, much less mine.
Correct.
So, Mr.
Was that
Vante,
case, sorry, was that case in our court or was that a court 2 case?
court 2 case. No,
Okay,
it's court 1
I'll
case.
tell
It's
him.
ours. It's ours.
Yeah.
Okay, well then I'll put him back on for next week if he's not out.
And he could always appear in front of any other judge during this week, as long as he learns not to talk.
Yeah.
Anything else?
Nope, that's it.
All right.
Thank you
See you
guys.
guys later.
I love instant.
Well, you're mean, Amanda.
Really do. Okay, so the next one I have is out of Washington. And the reason it caught my eye is just, I really don't love like talking about the like looks of people, but this one, I mean, you tell me what you think, what your first thought is. And as always, everybody is innocent until proven guilty in a court of law. All of these people are just innocent bystanders to this. Okay, here we go. It was the look and it was the name that got me.
It's done.
Okay, yeah, let me
go.
here.
Thanks, Mr. Silva.
Thank you.
This is Washington State.
Hello.
Hi, what is your name?
I am Damian Smotherman.
Did y'all hear that? His name is Damian Smotherman.
Okay, thank you.
If Mr. Smotherman's case comes on for arraignment, that's cause number 23L000901. It's a single count of assault in the 4th degree domestic violence. I have reviewed with Mr. Smotherman the nature of the charge against him, the minimum and maximum penalties associated with that charge. We'd waive a formal reading of probable cause, stipulate to PC for the purposes of today's hearing only, and enter a plea of not guilty. I am asking the court to consider a PR release in this case, and I have a little more information for the court about that if needed. Mr. Smotherman is seeking appointment to our office. He gave me some information that from my perspective makes it clear that he is eligible. So Mr. Smotherman takes home an amount that is above the typical cutoff limits. He indicated to me that his take-home pay ranges between $2,800 and $3,000 depending. However, at this point, he's unsure if he has retained that employment due to the fact that he's been booked into jail. He also let me know that his monthly expenses are close to $2,800, so at least $2,600. In other words, basically all of his income goes toward expenses, living expenses and whatnot, and that he does not have money in the bank to retain an attorney. And under RCW 10-101-010 subsection 3D, one of the definitions of indigency, is that an individual is unable to pay the anticipated cost of counsel for the matter before the court because his or her available funds are insufficient to pay for retention of counsel. So from defense's perspective, that section of the statute actually does mandate appointment in this situation, and so I am asking for appointment here today.
I will appoint Harwath Law. However, I will ask for a promissory note that is waivable upon proof of indigency. Okay. I'll hear from the city.
No objection to a PR release. There's no criminal history and no history of failures to appear. No objection to the court appointing of counsel subject to proof of actual financial need.
I'm setting an out of custody hearing on August 1st at 1 p.m. Sir, you have a court on August 1st at 1. I have appointed an attorney for you. Their information will be on the paperwork that you get today. Please reach out to them so that they can be ready for your next court date.
The city is also requesting a no contact order with the victim, Ira Williams.
Okay.
And I would ask that the court for a civil standby at the address, which I can provide, and it's just the address from Discovery.
Okay. So between now and your next court date, sir, have no criminal law violations. Update any address changes with the court. Use only your true legal name and date of birth. I'm actually going to ask you not to possess or own any firearms. Abide by a no contact order that I will be signing today.
Yes, I understand, Your Honor.
Okay, good. And I'm saving that document for review and signature, please.
I'm working on the no contact order.
Okay. And Ms. McCracken, are you able to sign your documents?
I'm working on reviewing the pretrial release commitment.
I see your name already there, but.
Oh, yeah, so I go in, if I have time, I try to go in and.
So I think the most interesting thing about that one was just the name. It's pretty standard from there on out. But I don't know, stop fighting with your family. There are so many domestic violence cases and I just don't get it. Just like leave or walk away, something. Okay. So I did not get my video's audio fixed, but that's okay. We're going to go back to nice Judge Weaver. Smoothly, almost. Okay, present, stop, present, share. And thank you so much for sticking with me. This is not what I wanted to do. It's not what I wanted to do. Stop screen. This is why these aren't real live streams. I will not do a real live stream until I've figured out and gotten all the kinks out. I'm thinking maybe like 20 or 30, maybe, just to work it out. Yeah, this is what he reminded me of. I think it's the one in California who would like sneak into people's windows. They had like very similar hair. Somebody in the chat, tell me what his name is. This Hillside Strangler? No, it was something. I watched like the documentary on it and it was actually really dark, really kind of scary. So we'll watch a little bit more Judge Weaver and see if he has anything interesting for us today. But yeah, and the glasses. When this plays, I'm gonna try to pull up a picture of the guy. Yes, thank you, Mortimer Duke. This guy, he just really reminded me of that guy. And to have the name Damien, what was it? Smotherman? Like, come on. Like, why would you do that to your son? I don't know. His parents had like a sixth sense of humor. All right, here we go.
Ms. Privet, were you present when I introduced myself to everybody?
Yes,
Did you hear the rights that you have?
yes, sir.
All right, then. Are you agreeing to appear by video and waiving your right to confront your witnesses in open courtroom?
Yes, sir.
All right. Court now calls for trial, cause number CCCR-23-714-1, the state of Texas versus Brianna Rochelle Privet. What says the state?
State's ready, Your Honor.
Thank you, Mr. Davis. What says the defense?
Defense is ready. We waive reading of the information.
That's it.
Thank you, Mr. Eldridge. Good afternoon again, Ms. Privet.
Good afternoon.
Your attorney announced right today for your trial for the Class A misdemeanor accusation of criminal trespass. Were you aware that today is your trial for that accusation?
Yes, sir.
Do you read, write, and speak the English language?
Yes, sir.
Have you in the past, are you presently being treated for any kind of psychiatric condition?
Yes, sir.
Are you currently being seen by a physician?
Yes, sir.
Are you on any medications?
Yes, sir.
All right, then. Has the county been providing those medications to you?
Yes, sir.
All right. Ms. Privet, can we have an agreement? This doesn't have to be done today. If at any time you want to stop, you tell me and we'll stop. Also, if at any time during this hearing you want to talk semi-privately with your lawyer, if you'll just tell me, I'll create an electronic breakout room and you consult with your lawyer. Do you understand that?
Yes, sir.
Can we have that agreement that you'll tell me if you want to stop?
Yes, sir.
All right. Thank you, Ms. Privet. You're here today on this trial, this Class A misdemeanor criminal trespass. To that accusation, how do you plead, guilty or not guilty?
Guilty.
Thank you, Ms. Privet. Before I accept that plea, however, I do need to make an inquiry on the record as to your understanding of today's proceedings. Before me, I have the negotiated plea bargain agreement that you want me to follow. It is attached to a plea memorandum which reflects your signature throughout the document. Do you recall signing the plea memorandum with the assistance of your attorney prior to today's trial?
Yes, sir.
Any questions about this document you may have had that Mr. Eldridge could not answer?
No, sir.
All right, your signature tells me you know that you have constitutional rights and you know how to use them, but today you don't want to in exchange for the plea bargain agreement. So, for example, do you know what a jury trial is?
Yes, sir.
Would you like one?
No, sir.
Ms. Privet, I'm convinced you understand the rights that you're waiving, as evidenced by your responses to me during our conversation, your signature, most importantly, your attorney's signature, which tells me you and your counsel talked prior to deciding to waive your right. So I'm not going to read this whole document to you. I would like to, though, put you under oath and ask you a few questions. You have an absolute right to remain silent. You waived it by pleading guilty. You have an absolute right not to give evidence against yourself. You waived it by signing the judicial confession. You understand you don't have to do either of those two things?
Yes, sir.
So here's my question. Will you waive your right to remain silent? Let me put you under oath and talk to you about this.
Yes, sir.
All right, raise your right hand. Do you swear or affirm to tell the truth?
I swear.
Thank you. Put your hand down. Ms. Privet, did you voluntarily plead guilty and did you voluntarily sign the judicial confession only because you're guilty and for no other reason?
Yes.
Are you satisfied thus far with Mr. Eldridge's representation?
Yes.
Mr. Eldridge, you feel comfortable expressing an opinion if you have one as to your client's competent to stand trial?
I do. I've had several discussions with her. I believe she's competent, Your Honor. I know she's taken some medications, but she's not incompetent. She's been able to assist with her defense.
Excellent, Mr. Eldridge. Thank you. Mr. Davis, has the state complied with the Michael Morton Act and that you made available to the defense the evidence in your possession?
Completely, Your Honor.
Thank you, Mr. Davis. Mr. Eldridge, are you satisfied the state's complied with the Michael Morton Act?
Yes, I am, Your Honor.
And did you discuss with your client the evidence made available to you?
Yeah, we talked. Yes, we talked.
Thank you. Ms. Privet, today's your trial. The state accused you of a criminal act. They investigated it. They felt confident they proved your guilt beyond a reasonable doubt at today's trial. After they collected the evidence, they made it available to your attorney, turned it over to him. Did you have a conversation with your attorney about the evidence that the state wants to use against you today?
Yes, sir.
Today's risk at your trial is up to 1 year in jail, up to $4,000 fine, or some combination of fine and confinement. Today, however, you're saying, Judge, sentence me to 90 days, don't assess a fine, go ahead and assess court costs. Give me 69 days jail credit. This is an attempt on your part to make a time-served sentence, meaning you're done. You have enough credit for your confinement and enough credit to be applied towards your court costs. Did I announce your agreement correctly?
Yes, sir.
Well, I'm not bound to follow that agreement. If I choose not to, I'll tell you, I'll let you withdraw your plea of guilty. However, and I'll let you have a new trial. However, if you do have a problem and you don't reduce it to writing today so I could read it, try to fix it, your odds of winning that complaint on an appeal or a writ, very, very slim. You understand that?
Yes, sir.
Anything about this conversation make you change your mind about your decision to plead guilty?
No, sir.
Brianna Rochelle Privet, I find your plea has been made knowingly, intentionally, and voluntarily. Further, I find evidence sufficient to support a finding of guilt beyond a reasonable doubt, and I now do find you guilty of having committed the Class A misdemeanor offense of criminal trespass. Mr. Davis, anything in bar of sentence?
No, Your Honor.
Mr. Eldridge?
No, Your Honor.
With nothing in bar, having found you guilty, I sentence you to serve 90 days at the Potter County Detention Center. I will not assess a fine. I'll assess court costs. I'll give you 69 days jail credit. Ms. Privet, I did what you requested me to do. Would you like to file a notice of appeal complaining of a mistake or an error?
No, sir.
Would you like a new trial?
No, sir.
All right, then what questions do you have, Ms. Privet?
I don't think I have any questions, sir. I just want to say
Excellent.
thank you.
You're very welcome. Excellent, Ms. Privet. Mr. Davis, any other matter before the court?
Oh, Your Honor.
Eldridge?
No, sir.
All right, good luck. Give fingerprint to the deputy. Court is adjourned.
Hey, Judge, that's all I have. May I be excused?
You may be.
All right, thank you, Judge. Take care.
Perfect time. Tiara Nicole Hill. Who's Miss Hill's attorney? How do you say your client's first name?
Tiara.
Tiara. Okay, good. Holy cow. Good afternoon, Miss Hill.
Hello, how are you?
I'm good. Are you on a walker?
Yes, sir.
All right, then can you stand during this hearing?
I can stand a little bit, but if I have to sit down, I can sit down on my walker.
Oh, you have a chair in your walker?
Yes, sir.
All right. I want you to know if you got to sit down, just sit down, okay?
Yes, sir.
You want to start sitting down or do you want to stand?
I'll go ahead and sit down because my hip hurts.
That's a good idea. You don't go, yeah, go sit by that microphone, the best part. Scoot to your left.
To the left?
To
Okay.
the left, to the left, to the left,
Okay.
as the song goes. All right, then. Miss Hill, were you present when I introduced myself to everybody?
Yes, sir.
All right, then. You understand you have a constitutional right to be here?
Yes, sir.
Are you going to waive that right and agree to appear by video?
Yes, sir.
All right, thank you, Ms. Hill. The court now calls for trial cause number CCCR-21-447-1, the state of Texas versus Tiara Nicole Hill. What says the state on its motion to revoke?
State's ready, Your Honor.
Thank you, Mr. Davis. What says the defense?
We're ready, Your Honor. We'll waive reading of the motion.
All right, then. Thank you, Ms. Natardis. Ms. Hill, good afternoon again.
Yes, sir.
Your attorney just announced rate today for your trial for the state's motion to revoke your probation on the Class A misdemeanor allegation of false alarm or report. Were you
Yes,
aware
sir.
that today is your trial for this accusation?
Yes, sir.
Do you read, write, and speak the English language?
Yes, sir.
Have you in the past, are you presently being treated for any kind of psychiatric condition?
No, sir.
Are you a United States citizen?
Yes, sir, I am.
All right. Then. What the state has to prove
I've
today.
got a lot of him,
Excuse me, Ms. Hill,
He's-
is that you're the one
I've
and
been
same
watching him
person
for a long
who
time.
pled guilty, who had probation explained to him. And after that probation was explained to you, it's alleged that you violated your probation. Now, you don't have a right to a jury trial. The trial is just to me. Now, I have a negotiated plea bargain agreement in front of me. You still have all the same rights about not giving evidence against yourself, but if it's an agreement, what I would like to do is have you waive your right to remain silent. If you want to, let me place you under oath and I'll prove up what's necessary to see if there's an alleged violation. You understand that?
Yes, sir.
And likewise, I don't have to find all of these violations. If all are true, that's fine, but if only some are true and the other are not true, you just got to say true or not true. And the final thing I need to say is there's no risk today. This agreement you have is not binding upon me, although it appears that, what was the underlying sentence?
The underlying sentence, Your Honor, was 180 days.
Thank you, Mr. Davis. I never can find it on these misdemeanor motions to revoke. It appears to me you want to plead true and get the original plea offer. But nonetheless, if I choose not to follow this plea bargain, I'll let you withdraw your pleas of true. We can start over. We can do this in person if necessary. Do you understand that?
Yes, sir.
So there's no risk today. Either you're going to get the deal you want or we're going to start over, okay?
Yes, sir.
All right, then. So I'm asking right now, will you waive your right to remain silent? Let me
I
place you
like
under
how
oath.
well he explains
Yes,
all
sir.
this stuff.
Raise your right hand.
Yes, sir.
Tiara Nicole Hill, you solemnly swear to tell the truth.
Yes, sir, I do, I swear.
All right, then. Put your hand down, Ms. Hill. Ms. Hill, are you the same Tiara Nicole Hill who on August 3rd, 2022, pled guilty to the accusation, Class A accusation of false alarm or report?
Yes, sir, I am.
After that plea, were you then sentenced to what appears to be 180 days in jail, and then that confinement probated for 12 months? Is that what happened?
Yes, sir.
Did you
If
just
you're
say
not sure,
false
you know, you
alarm?
can consult with your lawyer if you want to.
No, it's all right, but it's all right.
All right, it's all right.
Yes, sir.
All right, then. After that plea of guilty and that sentence, did you have a meeting with your probation officer?
Yes, sir, I did.
Did he or she go over the rules and conditions of probation?
No, they made me sign some papers, but they didn't explain to me. I told the lady that, I had to have my hip replacement. So I called and told her that that's the only reason why I stopped going, because I couldn't get out the house because I didn't have a walker at the time.
All right, you can plead not true to that if it's not true, but a lot of these allegations appear to be drug use. Did
Oh,
they
yeah,
talk about?
I made it to that. Those are.
Hang on, Ms. Hill, did they talk about you can't break the laws?
Yeah, they did. They told me.
Did they
that.
say you can't do drugs?
Right.
And they said you had a report, right?
Right.
All right, those seem to be the major rules I'm worried about. So let's have a conversation.
Okay, yes.
Is it true or not true? Well, the state filed a motion to revoke outlining all these violations, and either they need to serve it to you or you can have a conversation with your lawyer. Did you have a conversation with your lawyer about these violations?
Yes, sir.
All right, then. So what I want from you now is a true or not true statement. And you got to remember, I see one violation.
Right.
So is it true or not true that you violated condition 2, which required you to abstain from the use of narcotics, drugs, or any controlled substance in any form at any time during the period of supervision unless taken under a physician's direction or prescription? So is it true or not true that you used methamphetamine on or about August 31st, 2022, as evidenced by your admission to CSO Chisholm?
True.
Is it true or not true that you smoked marijuana on or about August 31st, 2022, as evidenced by your admission to CSO Chisholm?
True.
Is that true or not true that you smoked marijuana on or about December 6th, 2022, as evidenced by an admission to CSO Chisholm?
True.
Allegation D is you used
this was from
methamphetamine on or
today.
about 12/9/2022, as evidenced by your admission to CSO Chisholm.
True.
It goes on to state that you violated condition 4, which required you to report to the supervision officer as directed by the judge, me, or supervision officer, and obey all rules and regulations of the Community Supervision and Corrections Department. So is it true or not true that you did not report for the months of January, February 2023?
Yes, it's true, sir.
All right, it's true. And then it says you violated condition
He will
104,
lure you in
requiring
with
you to
that
abstain from the
friendliness.
consumption of alcohol in any form, and that you violated this condition. Is it true or not true by consuming alcohol December 12th, 2022?
True.
All right, the court finds that all the probation violations are found to be true. And as such, I'm going to revoke the probation. I find that you're the one and same defendant who knowingly, intentionally, voluntarily pled guilty, and that the evidence is sufficient to support a finding of guilt beyond a reasonable doubt, having previously found you guilty of this Class A misdemeanor of false alarm or report. I'm going to impose the original sentence, which was 180 days confinement in Potter County Detention Center. I will not impose a fine, and I will impose court costs. And I will give you 23 days jail credit. Ms. Hill, I did, as requested in your plea bargain, would you like to file a notice of appeal complaining of a mistake or an error?
No, sir.
Would you like a new trial?
No, sir.
All right, then. What questions do you have for me, Ms. Hill?
I don't have any questions for you, sir.
All right. Thank you, Ms. Hill, for working this out. Mr. Davis, any other matter before the court?
No,
I
Your Honor.
have several.
Thank you. Ms. Natardis.
Okay, Richard.
Nothing from the defense, Your Honor.
What?
All right, understood.
What? Okay, what is an accusation of false alarm or report? Is that like pulling a fire alarm or reporting a crime that didn't happen? Yeah, I really want to know. And like this was today. So had I previewed this, I probably maybe could have looked it up. I don't know. I'm used to looking up court records in Michigan, but not Texas. So I don't know how readily available they are. But that would be a really good hiding spot. But yeah, that's a first for me that I've heard as far as charges and arraignments go. Maybe it's because I'm always halfway paying attention, but I don't know, kind of interesting. Let's see what else he has.
Thank you for working it out. Give a fingerprint to the deputy. Court is adjourned. Good luck, Ms. Hill.
Thank you.
You're welcome.
Judge, that's all I have. May I be excused?
Excellent. You may see Hillary. Tell Kenneth he's too relaxed to be convicting people or indicting.
I will tell him that. Thanks, Judge. See y'all.
See ya. Ernest Hammond. Man, the DA just got boned in all of this. Justin, how come you couldn't get Avis to shuffle one to the top? What kind of stroke do you have?
It's a conspiracy.
Well, I'm just gonna have to be quiet. All right, Ernest Hammond, are you there? There we go.
I am.
Mr. Hammond, did you hear me or were you present when I introduced myself to everybody?
Oh, yeah, earlier, yes, sir. I can read your name on the screen here too a little bit.
Well, excellent. What does it say?
Something Weaver. I don't know if that's a V or W in your name. There, Waltz, I believe.
Yeah, Walt, that's me.
Okay, cool.
I never been there. When,
glasses. Excuse me, sir.
so I never been there when my name's up there. So
Okay.
I wouldn't know.
Well, it's legible.
Well, good. Mr. Hammond, you have an absolute right to be in my courtroom today, or you can waive that right, as it appears you're waiving all your other rights. Are you agreeing to appear by video?
Yes, sir.
All right, then. The court now calls for trial cause number CCCR-23-541-2. And, oh, here we go. There's a felony. And cause number 84058-C-CR. Both, no.
That's a different defendant.
It was paperclip to it. I thought I was being so smart.
Yes, Stephen.
Just 23-541, style state of Texas versus Ernest Hammond. What says state?
State's ready to proceed, Your Honor, and just for the record, this will be a plea of guilty to an information.
Judge, cause number 83765 is his felony possession of controlled substance.
Here we go. I had a different felony paperclip to this misdemeanor. And just to be clear, I'm also calling 83765-D-CR, which is the state of Texas versus Ernest Frank Hammond III. And on the misdemeanor ending in 541, it's Ernest Hammond. The DA has announced ready on its information. What says the county attorney's office?
State's ready, Your Honor.
Thank you, Mr. Davis, and thank you, Mr. Sanders. What says the defense?
Judge T.D. Hammonds for Ernest Hammond III. We are ready to proceed. I can tell you we have discussed both of the charging documents. We'd waive the form reading that document. He has also agreed that he will proceed on an information rather than an indictment.
Excellent. Thank you, Mr. Hammond.
Oh no. Oh no. I'm so sorry. I'm so sorry.
Boy, it's confusing. Your name and then your client's name.
Right?
It's fairly unique.
I got lucky, sir.
It's making my brain melt. Mr. Hammond, your attorney announced right today for 2 accusations. Were you aware that today is your trial for both of those accusations?
Yes, sir.
Do you read, write, and speak the English language?
Yes, sir.
Have you in the past, are you presently being treated for any kind of psychiatric condition?
No, sir.
Are you a United States citizen?
Yes, sir.
To the stated accusation, Class A misdemeanor assault alleging domestic violence, how do you plead, guilty or not guilty?
Guilty, sir.
And to the stated accusation in cause number 83765-D, possession of a controlled substance, penalty group 1/1-B, less than 1 gram, a state jail felony, how do you plead, guilty or not guilty?
Guilty, sir.
Thank you, Mr. Hammond. Before I can accept the plea of guilty, not the cause, I do need to make an inquiry on the record as to your understanding of today's proceedings. Before me, I have the 2 negotiated plea bargain agreements, and they're attached to 2 separate plea memorandums, all reflecting your signature. Do you recall signing these plea memorandums with the assistance of your attorney prior to today's trial?
I do, sir.
Any questions about these 2 documents you may have had that your attorney, Mr. Hammond, could not answer?
No, sir.
Your signature tells me that you know that you have constitutional rights, you know how to use these rights, but today you don't want to in exchange for the plea bargain agreement. So
Correct,
for example, do you know what a jury trial is?
I do, sir.
Would you like a jury trial in either cause?
No, sir.
Mr. Hammond, I feel like you understand the rights that you're waiving as evidenced by our conversation, your signatures, most importantly, your attorney's signature, which tells me you 2 talked about this before deciding not to use your rights. So I don't feel the need to read both of these plea memorandums verbatim. I would, however, like to have a conversation with you under oath about a few things. You have an absolute right to remain silent. You waived it by pleading guilty to both of these charges. You have an absolute right not to give evidence against yourself. You waived it by signing 2 judicial confessions, admitting to each and every element of these 2 offenses as alleged in the information. No one can make you do that, Mr. Hammond. However, today, if I accept it and believe it, that's enough evidence at your trial to support my finding of your guilt. Do you understand that?
I understand, sir.
So my question is, will you waive your right to remain silent? Let me place you under oath and ask you a few questions.
Yes, sir.
Raise your right hand. Ernest Frank Hammond III, also known as Ernest Hammond, do you solemnly swear to tell the truth?
Yes, sir.
All right, put your hand down. Ernest Hammond, did you voluntarily plead guilty, and did you voluntarily sign the
I
two
missed
judicial
it.
confessions only because you're guilty and for no other reason?
Yes, sir.
Are you satisfied thus far with your attorney's representation of you?
Yes, sir.
Mr. Hammond, do you feel comfortable expressing an opinion, if you have one, as to your client's competence to stand trial?
I do believe he is competent, Judge.
Thank you, Mr. Hammond. Asking the county attorney's office, Mr. Davis, has the state complied with the Michael Morton Act and that you made available to the defense the evidence in your possession?
To the best of my knowledge and ability, Your Honor.
Thank you, Mr. Davis. Asking the DA's office, Mr. Sanders, has the state complied with the Michael Morton Act and that you made available to the defense the evidence in your possession?
Yes, Your Honor, it appears that we have.
Thank you, Mr. Sanders. Mr. Hammonds, are you satisfied that both of these government agencies have complied with the Michael Morton Act?
I am, sir.
I do believe they have, Judge.
And did you discuss with your client the evidence that was made available to you in both causes?
Yes, sir.
Thank you, Mr. Hammonds. Mr. Hammond, today's your trial for both of these criminal accusations. The state accused you of criminal conduct, which they investigated. They believe they secured evidence to prove your guilt beyond a reasonable doubt in both causes in today's trial. They then turned over all that evidence to your attorney. Did you have a conversation with your attorney about the evidence that the state of Texas and these respective offices wish to use against you today to prove your guilt?
I did, sir.
Your risk at today's trial on the misdemeanor is up to 1 year in jail, up to $4,000 fine. And on the state jail, it's anywhere from a 2-year maximum sentence flat time down to 180 days flat time and or a fine not to exceed $10,000. You're asking me today to find you guilty on the misdemeanor, sentencing you to 90 days with 125 days jail credit, no fine, but I'll assess court costs. This will be time served. You are done with no obligation. On the state jail, you're saying, Judge, despite my plea of guilty, don't. Instead, defer any such finding for up to 3 years, and I'm going to place you on deferred adjudication probation. I am going to, in addition, assign court costs and court-appointed attorney's fees, but I will not be assessing a fine as near as I can tell. Did I properly announce your agreement in both these matters, Mr. Hammond?
Yes, sir.
Well, I'm not bound to follow this agreement. If I choose not to, I'll let you know. I'll withdraw your plea of guilty. I'll let you withdraw it, and it could not be used against you at a future trial. And but if I give you what you want and later you try to appeal, unless you reduce to writing right now what your concerns are, your errors or mistakes, and let me try to fix it, your odds of winning that later on an appeal or a writ are very, very slim. You understand that, correct?
I understand, sir.
Likewise, on the deferred, it's a great opportunity. If I do this, you leave this courtroom, this jail cell, without a felony conviction for the rest of your life until you die. You'll always have a record. You can't expunge it, but you can seal it. It'll show arrest, plea of guilty, deferred, and then hopefully dismissal. Then you can seal it so that only the government can look at it and not your neighbors or apartment complexes, stuff like that. You understand it?
I understand, sir.
That's the good side. The bad side's this. If you violate probation and the district attorney's office approves it, you're saying, Judge, maybe not me, maybe the district judge, you get to pick the punishment. Maybe this is just a 180-day in jail, state jail felony. Then again, maybe it's a 2-year state jail, $10,000 fine, state jail felony. You understand that?
I understand, sir.
Anything about this conversation make you change your mind about your decision, plead guilty in both these causes?
Yeah, correct, sir. Plead guilty.
Anything about this conversation make you change your mind about your decision to plead guilty?
No, sir.
And we can't talk at the same time, so.
Sorry, sir.
It's all right. Ernest Frank Hammond III, also known as Ernest Hammond. I find that both these causes your pleas are made knowingly, intentionally, voluntarily. Further, I find evidence sufficient in the misdemeanor 23-541 sufficient to prove your guilt beyond a reasonable doubt. And I now do find you guilty of having committed the Class A misdemeanor offense of assault, alleging domestic violence in cause number 83765-D. I find the evidence sufficient to support a finding of guilt beyond a reasonable doubt, but I'm not going to make that finding today. I'm going to defer that finding 3 years, place you on deferred adjudication probation, as well as all the other conditions of probation you agreed to in your plea memorandum. Now, on the felony deferred, you don't have a right to an appeal, but you have a unique right. If you want to not be on probation, you just want to go ahead and be sentenced, contact Mr. Hammonds. He'll file the right motion, and some judge will hear that punishment hearing and decide what to do with it. Do you understand that?
I do, sir.
On the misdemeanor, would you like to file a notice of appeal complaining of a mistake or an error?
No, sir.
Would you like a new trial?
No, sir.
All right then. Mr. Hammond, people succeed in probation. You don't have to go to state jail facility, go to prison. And that's going to happen because you're going to meet your very first probation officer. I'm sure directions will be left there by an agent of the probation department. Is there any other hold on you at the facility?
No, sir.
Mr. Johnson, what's his reporting directions?
I just sent them out to the jail judge. I wasn't aware that he was in the probation thing. We sent for him to report on July 19th at 2:00.
Did you get that, Mr. Hammond?
July 19th, 2:00. Got it.
Santa Fe building.
I know
Now, you're gonna have the probation rules explained to you. If you leave that meeting with a question, contact Mr. Hammond. Nobody here wants you to go to prison. You understand that?
I understand. Thank you, sir.
All right then. What questions do you have?
None, sir.
Thank you. Mr. Davis, any other matter before the court?
No, Your Honor.
Sanders?
No, Your Honor.
Mr. Hammonds?
No, Judge.
All right. Good luck. Give a perfect fingerprint to the deputy. Court is adjourned.
Thank you, sir.
Welcome.
Thank
I
you,
believe
Judge.
that's the last misdemeanor, Your Honor, may be excused.
You
If I
may be.
remember
Nothing but felonies on the
correctly,
horizon.
hang on.
See you,
hang
Mr.
on,
Davis.
hang on.
All right then.
Okay. If I remember correctly, just from watching Judge Weaver for a really long time, I believe before he was a judge, he was a defense attorney, because I know sometimes he'll catch himself like saying, come on now, defense, you guys have to get a win. You guys never get any wins. And of course, he's always saying it in jest. He's not, like on the defense's side. I just think it's interesting to know what like what judges were doing before, like as a lawyer, if they were prosecutors or defense attorneys. And sometimes I try to guess and I'm usually wrong, but here I pulled up to show you guys where Potter County was. Here we go. So Potter County is like kind of close, maybe close to Amarillo, but like not really. So it's way up there, and it's very, very, see, right here. And that's a really cool thing. Anyways, okay, I just wanted to show you that Amarillo, but I feel like I don't see big city cases there. It seems like maybe that court in particular takes care of the more rural, I don't know, towns or whatever they're called in Texas. Okay, sorry. Let's go back. Oh, wrong one. Okay. There we go. Wait, no. Okay, someday I'm gonna be smooth, and it's all gonna go according to plan. I can't believe I decided to show Amarillo. Like that was really, really silly. Okay, right there. Share this screen. Press play and stop messing around.
Talk to Rocky Allen Bowers. Well,
Now the
rings a bell.
felonies.
Who's the attorney for Mr. Bowers?
Archer Walt Weaver.
Archer Walt Weaver? What a weird name.
Judge, I'm the attorney. Archer.
There-
I have to identify myself because there's so many people on the screen.
Are you new to our country?
Sorry, I just waited so long. I kind of fell asleep.
That's wow. That's Paul. That's classic Paul. Mr. Bowers, can you hear me?
Yes, sir.
Were you present when I introduced myself to the court?
Yes.
Do you understand you have a constitutional right to appear in my courtroom?
Yes, sir.
Are you agreeing to waive that right?
I remember that.
And
Mortimer.
agreeing to appear by video?
Yes, sir.
All right then. Court now calls for trial cause number 84058-C-CR, the state of Texas versus Rocky Allen Bowers. What says the state?
State's ready to proceed on a plea of guilty, Your Honor.
Thank you, Mr. Sanders. What says the defense?
The defense is ready and will waive the reading of the indictment.
Thank you, Mr. Archer. Good afternoon, Mr. Bowers. Can you hear me?
Yes, sir.
All right, just respond to me when I talk. That way we know that you're there and there's not audio visual difficulties.
Yes, sir.
Mr. Bowers, your attorney just announced right today for your state jail felony accusation of theft for property less than 2,500 with 2 or more previous convictions. Were you aware that today is your trial?
Yes, sir.
Do you read, write, and speak the English language?
Yes.
Have you in the past, or are you presently being treated for any kind of psychiatric condition?
No, sir.
Are you a U.S. citizen?
Yes, sir.
To the stated allegation, how do you plead, guilty or not guilty?
Guilty.
Thank you, Mr. Bowers. Before I accept that plea, however, I do need to make an inquiry on the record as to your understanding of today's proceedings. Before me, I have a negotiated plea bargain agreement reflecting your signature. Do you recall signing this document with the assistance of your attorney prior to today's trial?
Yes, sir.
Any questions about this document you may have had Ms. Archer could not answer?
No, sir.
Your signature tells me you know you have constitutional rights and you know how to use them, but today you don't want to in exchange for the plea bargain agreement. So for example, you know what a jury trial is?
Yes, sir.
Would you like one?
No, sir.
All right, then. Mr. Bowers, I feel confident you understand the rights that you're waiving as evidenced by your responses to me, your signature, and most importantly, your attorney's signature, which tells me that you two have discussed this before deciding not to use your rights. So I'm not going to read it all to you, but I would like to talk to you nonetheless under oath about a few things. You have an absolute right to remain silent. You waived it by pleading guilty. You have an absolute right not to give evidence against yourself. You waived it by signing a judicial
I bet he was an
confession.
excellent defense
No one can make you do
attorney.
either of these two things, Mr. Bowers, but that is enough evidence today at your trial to support my finding of your guilt. Do you understand that?
Yes, sir.
So here's my question. Will you waive your right to remain silent? Let me place you under oath and discuss a few things.
Yes. Yes, sir.
Raise your right hand. Do you swear or affirm to tell the truth?
Yes, sir.
All right then. Rocky Allen Bowers, did you voluntarily plead guilty? And did you voluntarily sign the judicial confession admitting to each and every element of the offense as alleged because you are guilty and for no other reason?
Yes, sir.
Are you satisfied thus far with your attorney's representation?
Yes, sir.
Mr. Archer, do you feel comfortable expressing an opinion if you have one as to your client's competence to stand trial?
I do. I believe he's competent.
Thank you, Ms. Archer. Mr. Sanders, has the state complied with the Michael Morton Act and that you made available to the defense the evidence in your possession?
Yes, Your Honor, we have.
Thank you, Ms. Sanders. Ms. Archer, are you satisfied that the state's complied with the Michael Morton Act?
I am.
Did you discuss with the client the evidence that was made available to you?
Yes, I did.
All right, thank you, Ms. Archer. Mr. Bowers, today's your trial. The state accused you of a criminal act. They investigated it. They felt confident they found enough evidence to prove your guilt beyond a reasonable doubt at today's trial. They then turned over all that evidence to your attorney. Did you have a conversation with your attorney about the evidence that the state of Texas wants to use against you today?
Yes, sir.
Your risk at today's trial is up to 24 months at a state jail facility and or up to a $10,000 fine and a minimum sentence of 180 days in jail. Today, however, you're saying, Judge, accept my plea of guilty, sentence me to 14 months at a state jail facility, assess court costs, court appointed attorney's fees. Did I properly announce your agreement?
Yes, sir.
Well, I'm not bound to follow this agreement, Mr. Bowers. If I choose not to, I'll tell you, I'll let you withdraw your plea of guilty. It couldn't be used against you in the future, but if I give you what you want today and later you're sitting in a state jail facility thinking I did something wrong or you didn't understand it or Mr. Archer did something wrong, unless you reduce that concern to writing today where I can read it, try to fix it, your odds of winning that complaint on an appeal or a writ are very, very slim. You understand that?
Yes, sir.
Anything about this conversation make you change your mind about your decision to plead guilty?
No, sir.
Rocky Allen Bowers, I find your pleas made knowingly, intentionally, voluntarily. Further, I find it evidence sufficient to support a finding of guilt beyond a reasonable doubt, and now do find you guilty of having committed a state jail felony offense of theft of property less than 2,500 with 2 or more previous convictions. Ms. Sanders, anything in bar or sentence?
No, Your Honor.
Ms. Archer?
Nothing in bar.
Thank you. Having previously found you guilty, Rocky Allen Bowers, I sentence you to serve to 14 months at a state jail facility. I will not assess a fine. I will assess court costs and court appointed attorney's fees. Mr. Bowers, I did as you requested. Would you like to file a notice of appeal complaining of a mistake or an error?
No, sir.
Would you like a new trial?
No, sir.
What questions do you have for me, Mr. Bowers?
I'll have none.
All right.
Okay.
All right. Thank you. Ms. Sanders, any other matter before the court?
No, Your Honor, not pertaining to this case.
Ms. Archer?
Nothing further.
All right then. Good luck, sir. Give a fingerprint to the deputy. Court adjourned.
Thank you.
You have to please be excused, Judge.
You may be until Paul. I still don't like him. Oh, good. I guess there's always a challenge. And of course, it's George's client. Let me get my glasses on, see if I can decipher this. All right. Is Libin Abdullah Yusuf present? Would they please approach?
Ready to return.
Good afternoon, sir.
Good afternoon to you too, sir.
How do I say your name?
Liban Abdullahi Yusuf.
Liban Abdullah Yusuf.
Yes.
How do you spell your middle name?
Abdullahi.
All right, I've never seen it with an I before. Mr. Yusuf, were you present when I introduced myself to everybody?
No, not really.
All right, then. Well, let me introduce myself. My name is Walt Weaver. I'm the judge of County Court Law Number 1. I've been assigned the task to hear your trial today. I've reviewed the plea papers, and it appears to me you're prepared to waive a lot of your constitutional rights. Nonetheless, you have an absolute right to appear in my open court and face your accusers, or you can also choose not to use that right as well, and you can agree to appear by video. Are you agreeing to appear by video?
Yes, sir, I am.
All right. Thank you. The court now calls for trial cause number 83304. It does not have a letter following it, nor does the plea memorandum tell me which district court it is in. Mr. Sanders?
It's information.
No, it's a D case. He's been indicted into D court.
Yes.
I've got a copy of the indictment.
Guys, you're both talking at the same time, so we can't hear it anyway.
It's indicted into the 320th, Your Honor.
Thank you. Thank you both. And again, the court now calls for trial cause number 83304-D, the state of Texas versus Liban Abdullah Yusuf. What says the state on the information?
This is from today. And I
it's an
haven't
indictment, Your Honor.
watched it yet.
Oh, I just wanted to be sitting. What says the state on the
The video I
indictment?
was working
State's ready to
on,
proceed on a plea of guilty to the indicted.
I messed
Your
up
Honor.
the sound somehow, so I kind of
Thank
had
you,
to
Ms.
just
Saunders.
like
Sanders, what says the defense?
George Harwood
pull
appearing
this
on
out
behalf
of
Mr.
nowhere.
Yusuf,
I don't
and
know.
He desires to
I felt bad
enter a plea of
canceling
guilty
after
to
it was
the
already
indictment
supposed to
as
start.
written, and we waive the reading of the indictment.
All right, then. Thank you, Mr. Harwood. We're having a little bit of a hard time hearing you, Mr. Harwood. It sounds like you're in a Dixie cup, but I can still hear you, so don't panic.
Well, let me see if I can turn it up.
It's all right. Mr. Yusuf, your attorney just announced right today for your trial for the second-degree felony offense of burglary of habitation. Were you aware that today is your trial for the stated accusation?
Yes, I am, sir.
Do you read, write, and speak Danish language?
Yes, I do, sir.
Have you in the past, are you presently being treated for any kind of psychiatric condition?
No, I'm not, sir.
Are you a United States citizen?
Yes, I am, sir.
Mr. Yusuf, how do you plead then? Guilty?
I actually think that time he might have thought his middle name was a typo because he'd never seen it with an I at the end. But he does kind of like, I don't know, I feel like he's more amusing himself on the bench than really is, you know, insulting people. But I don't know. Maybe he is. And I'm just like blinded by his charisma or something. But I really like him.
Are not guilty to the stated accusation?
I'll be pleading guilty today, sir.
Thank you, Mr. Yusuf. Before I accept that plea, however, I do need to make an inquiry on the record as to your understanding of today's proceedings. Before me, I have the negotiated plea bargaining agreement that you're asking me to follow. It is attached to something called a plea memorandum, which reflects your signature throughout the documents. Do you recall signing the plea memorandum with the assistance of your attorney prior to today's trial?
Yes, I do.
Any questions about this document you may have had that your attorney, Mr. Harwood, could
His
not answer?
glasses switching
No,
always
sir.
kind of
Your signature tells me
is
you
cool
know
to
that you
me.
have
I don't wear
constitutional rights
glasses,
and you
but
know
it
how
looks
to
hard.
use those rights, but today you don't want to in exchange for the plea bargaining agreement. So for example, do you know what a jury trial is?
Yes, I do, sir.
Would you like a jury trial?
No, I do not, sir.
Okay then. Mr. Yusuf, I feel comfortable coming to the conclusion that you understand these rights that you're waiving as evidenced by our conversation, your signature on your plea memorandum waiving these rights, most importantly, your attorney's signature, which tells me you two discussed this before deciding not to use your rights. So I'm not going to read this whole thing to you. But I would like to have a conversation with you under oath about a few things. You have an absolute right to remain silent. You waived
This
it by
is the
pleading
last
guilty.
one, so we're almost done.
You have an absolute right not to give
Thanks for
evidence
sticking it
against
out.
yourself. And you waive that right by signing a judicial confession admitting to each and every element of this offense as alleged in the indictment. No one can make you do either of those two things, Mr. Yusuf. However, at your trial today, if I believe it and accept it as evidence, that's enough evidence today to support my finding of your guilt. Do you understand that?
Yes, I do, sir.
So here's my question to you, sir. Will you waive your right to remain silent? Allow me to place you under oath so I can ask you a few questions.
Yes, sir.
Ibn Abdullah Yusuf, raise your right hand. Do you solemnly swear to tell the truth?
Yes, I do.
Put your hand down, please. Mr. Yusuf, did you voluntarily plead guilty and did you voluntarily sign the judicial confession only because you are guilty and for no other reason?
Yes, sir.
Are you satisfied thus far with Mr. Harwood's representation of you?
Yes, sir.
Mr. Harwood, do you feel comfortable expressing an opinion if you have one as to your client's competence to stand trial?
He's competent, Your Honor. I've been representing him for some months and have no doubt as to his competency.
Thank you, Mr. Harwood. Mr. Sanders, has the state complied with the Michael Morton Act and that you made available to the defense the evidence in your possession?
It appears the state has complied, Your Honor.
Thank you, Mr. Sanders. Mr. Harwood, are you satisfied the state's complied with the Michael Morton Act?
I am, Your Honor, and I've discussed what evidence the state has with Mr. Youssef.
Thank you, Mr. Harwood. Mr. Youssef, today's your trial. The state accused you of a criminal act. They investigated it. At the conclusion of that investigation, they were confident they had found enough evidence to prove your guilt beyond a reasonable doubt. They then turned over all that evidence to your attorney. Did you have a conversation with your attorney about the evidence that the state of Texas wants to use against you today?
Yes, I did, sir.
Your risk at today's trial is confinement in the Texas Department of Criminal Justice anywhere from 2 years to 20 years and or a $10,000 fine in some combination of fine and confinement. Today, you're saying, Judge, in exchange for my plea of guilty and a waiver of these rights, accept it and sentence me to 5 years at the Texas Department of Criminal Justice Institutional Division, but probate that same sentence for 5 years. I am not to assess a fine, but I will assess court costs and court-appointed attorney's fees. Mr. Youssef, did I properly announce your agreement?
Yes, you did, sir.
Well, I'm not bound to follow this agreement. If I choose not to, I'll tell you, I'll let you withdraw your plea of guilty. It could not be used against you in the future. If I give you what you want today in a letter, you think it was a mistake or I need your right, Mr. Harwood made some error. Whatever your concern is, unless you reduce it to writing today, so I can try to read it and fix it for you, your odds of winning that same complaint later on appeal is very, very slim. Do you understand that?
Yes, I do, sir.
Anything about this conversation make you change your mind about your decision to plead guilty?
No, sir.
Liban Abdullah Youssef, I find your pleas are made knowingly, intelligently, and voluntarily. Further, I find the evidence sufficient to support a finding of guilt beyond a reasonable doubt, and I now do find you guilty of having committed the second-degree felony offense of burglary of a habitation. Mr. Sanders, anything in bar of sentence?
No, Your Honor.
Mr. Harwood,
No, Your Honor.
with nothing in bar, having previously found you guilty. Mr. Youssef, I sentence you to serve 5 years at the Texas Department of Criminal Justice Institutional Division. I will probate that same sentence for 5 years, placing you in adult probation. I will not assess a fine, but I will assess court costs and court-appointed attorney's fees to be paid over the term of probation. Mr. Youssef, I did as requested. Would you like to file a notice of appeal complaining of a mistake or an error?
No, sir.
Would you like a new trial?
No, sir.
All right, then Mr. Youssef, let's have a conversation. Most people succeed in probation. Probation is remarkably successful. That happens because you're going to meet your very first probation officer who's going to go over the rules with you. If you leave that meeting with the question, contact Mr. Harwood. No one here wants you to go to prison. Do you understand that?
Yes, sir.
Mr. Johnson, what is Mr. Youssef's reporting directions?
I sent out to the jail for him to come in on Wednesday at 2 o'clock.
Is that
That's the 19th.
thank you, Wednesday, 2 o'clock, Santa Fe building. Did you get that, Mr. Youssef?
Yes, I did, sir.
All right, then. What questions do you have for me?
I have no questions at this time, sir.
All right, thank you, Mr. Youssef. Mr. Sanders, any other matter before the court?
No, Your Honor.
Mr. Harwood?
Your Honor, I think the court needs to know he's already on probation out of Randall County for the same thing. And of course, I would assume that he'd only have to pay one probation fee. That was done probably within the last month, Your Honor.
I believe that is the policy of our probation department, and Mr. Johnson indicated the same by nodding his head in the affirmative.
Yes, sir.
But if it
I
is
was
a
the one that
problem,
did it, so.
Yeah.
but if it becomes a problem, Mr. Harwood, just please bring it up with me and we'll resolve it, okay?
Yes, Your Honor.
All right, then. Good luck, Mr. Youssef. To give a perfect fingerprint to the deputy, court is adjourned.
Thank you, Your Honor.
Thank you. You're welcome. Bye.
Bye.
Oh man, I hate when he cuts it off right away. Sometimes they talk and it's a lot of fun. Would that be a violation of what? What are you talking about? I don't know what a violation, like the defendant or the judge. Also, I do really now that banner is going to bother me. I have no idea. I thought maybe the circle had the word "the" written in it, like May the 4th be with you, because like "the" is just an article. Oh yeah. Yeah, I don't know. I don't know about that. But I'm thinking the reason why I thought may the 4th be with you is I thought there wouldn't be an O, but on the O, the word the would be because it's an article. So you're not going to waste banner paper writing out THE, right? I mean, as a teacher, I wouldn't want to like, I don't know, laminate all those extra letters. Okay. Yeah, I don't know. I guess I missed it. It is from today. This is either from today or yesterday. I get them mixed up. It's possible it was yesterday. I don't think it says birthday because there's not enough room for it to say happy. And why would there be an F? Yeah, you're right. They can. And I'm coming from a different place because I've been watching him for he zoomed in a lot. I've been watching him for a while. So I'll keep an eye on that. When I go, I need to go through them so I can cut out the boring ones. And 4th of July. But why would there be a Y? Okay, whatever. Thank you guys so much for coming. I'm sorry it was kind of like a hodgepodge today, but I spent a lot of time editing a SovSit video. I was trying to figure out how to do a counter, and because I wanted to count all the objections that this useless objections that this guy did, and I couldn't get. Oh no, KCC, not tonight. I got up at like 6 a.m. I've been watching court straight from 8 a.m. when I saw Cha. And I don't remember where. It was one of the courts. It just like blew out my eardrums in the car. It was like one of the first thing this morning. And then, yeah, I did. I posted the video. I posted the video that I kind of messed up. I hope the audio is okay because every time I was been exporting it like leading up into this, and every time I played it, it sounded really crackly. But anyway, yeah, that was loud. Yeah, that was early. That was a long time ago. So I'm court overload today. So I'm going to go to bed. Thank you guys. Until next time. Bye. Oh yeah. Like and subscribe. I remembered. Bye.